welcome. Good morning, everybody. All very welcome. My name's Tom Murray. I'm the chair of the CCABI Insolvency Committee, and I'm delighted to welcome you to today's webinar, which is put on by CCABI. And I'm delighted to welcome Cathy Shivnan, who's the Director of Insolvency Supervision with the Corporate Enforcement Agency. Just by way of background to today's presentation, who are CCABI? Well, CCABI is the consultative committee of accountancy bodies here in Ireland, and it's an umbrella group for the accountancy profession. It was established back in 1988, and it's there to coordinate the representative functions of the various accountancy bodies, ACCA, CPA, and of course Chartered Accountants Ireland, in the areas of common interest to the profession, and has a number of committees which respond to government and to regulatory initiatives in the respective areas. And I suppose today we're here with the Insolvency Committee, and I've been lucky enough to chair that for the last 18 months or so. And the Insolvency Committee's objective is to develop guidance for members in the whole area of insolvency work. And it's an area that we're seeing beginning to return post-pandemic to significant numbers of companies having to avail of the various restructuring or insolvency procedures that are out there. The committee deals with the changes in legislation and the statements of insolvency practice, and also response to issues in developing legislation coming down the track from the EU. So we've had we've a mandate to promote the work that we do, and a mandate to promote the work of the actual profession, and to try and help improve standards. And with that, we're going to have a series of interviews and conversations with various stakeholders. And it's with that I'm delighted to welcome Cathy today. By way of introduction, Cathy is the Director of Insolvency Supervision with the CAA. She qualified as a solicitor in 2011 and holds a Bachelor of Civil Law from UCD. She also holds a postgraduate diploma in insolvency and corporate restructuring from the Law Society of Ireland. And prior to joining the CAA, she worked with the court service and in various roles in the Office of the Revenue Commissioners, including acting as a solicitor in the commercial and litigation team of the Revenue Solicitors Division, and where a lot of us would know Cathy as the head of the Revenue's Dublin Insolvency Unit, where she managed all aspects of revenues involvement in liquidations, receiverships, and examinerships. So with that introduction and enough talk out of me, because we're all here to hear Cathy, not myself, I'd like to introduce you to Cathy. And Cathy, maybe you could give us a little bit of more background on yourself, and then we might have a chat about your journey through your career to your current position.
Thanks very much, Tom, and thanks very much to CCABI as well for inviting me on this morning. It's always good to get an opportunity to have a chat to liquidators and insolvency practitioners and just tell them a bit about what we're doing, and also, I suppose, how we can work a bit better together as well. So I suppose bit about me anyway. Obviously Tom has given you the edited highlights there. I started off in civil service about 20 years ago after I finished college, and I was in the WRC to start off with, which is, well, was the LRC at the time. So started off there, got my traineeship then, and I trained in employment law practice. So I kind of fell into insolvency by accident, really. When I went in, after I qualified then, it was not a great time to qualify as a solicitor. Yeah. So I was in revenue, and then was assigned to the commercial and litigation team. So as I said, I fell into insolvency. It happened to be one of the positions that was needed to be filled, happened to be attending the examiner's court and dealing with examinerships. So 4.5 years there, and then moved on to the insolvency unit then on promotion, and was there for another 4.5 years. Went over then to the personal tax policy and legislation unit then in revenue, and was there for 1.5 years before I moved to the court service. So I was a High Court registrar, and was mostly assigned to the Masters Court while I was there. And then just in May of last year, I joined the CEA as the Director of Insolvency Supervision. So kind of back to what I know best, and back to what I enjoy. So I've been here now since May last year. So we're just kind of still, I suppose, starting at the same time as more or less the CEA was established. It was technically the ODCE at the time, but obviously then from the 7th of July last year, when on establishment day, then the ODCE ceased to exist, and the CEA then kind of rose from the ashes, if you will.
love the way you say you fell into insolvency. I think most of us, I don't think anybody ever sets out to become an insolvency
No,
practitioner.
I don't. I don't think it's one of those things that
yeah,
you ask a primary school kid what you
yeah,
want to
yeah.
do.
I don't think it's high up in the career guidance of any of the schools out there. But
Yeah.
like most of us, it's been a very rewarding and it's been a very good career for most of us. And likewise, obviously, you may have fallen into it, but you've gone down the path. So you mentioned there that like you've joined um, ODCE/CA at the outset, I suppose, of the evolution of CA from the former ODC. And I suppose really, if you could maybe just for those of us, most of us should know, and I hope most of us know what CA is about. But maybe if you could give us a little bit of just a little bit of an overview of the role of CA broadly, and then perhaps your role within CA and how it impacts those of us,
It's, I suppose like to summarize it really, like we're
mm,
tasked with enforcing all aspects of company law, and like the ODC, the CEA's functions are pretty much the same as the ODCE's functions were. Like I think it's the structural aspect of it really that's the biggest changes. So obviously we are no longer an office of the Department of Enterprise and Trade. We're now a standalone independent authority, and that has a number of implications from the point of view of the ability to recruit our own staff, and we've increased resources, and we also have things like the ability to have our own vehicles at the Gardaí that are seconded here use. We can have more of a focus on recruiting specialised staff. We have a lot of obviously forensic accountants, solicitors. There's an increased Garda complement as well. It used to be the case that the Gardaí who were seconded to the ODC were assigned, but now we get to interview each one of them and just make sure that they are a really good fit. And we have a very good team in here at the moment. So really from the point of view, it's just increased corporate governance focus as well from ourselves because we're a standalone agency. We do have an increased budget. That means more resources, which is good news for me because I'll be speaking later about the various enforcement programs as well that the Insolvency Supervision Directorate will be starting out, or we're in the process of starting at the minute, but we will be kind of, I suppose, launching them properly in the next few weeks. So it's really just the same but different. It's a structural
same but different as that expression goes. And I suppose that's key because one of the key things is, obviously the whole function is the promotion of company law, but very importantly, and you alluded to there, we're going to talk a little bit later on about how that company law applies to us as liquidators and how the things that we need to be very, very, very conscious of. So if we were to say your direct role, your role is actually, as you said, director of insolvency supervision. So that involves everything from the practitioners ourselves down to your teams would look at the individual cases, the individual companies that were appointed over. Maybe just a little bit day to day of how that operates. Maybe if we could go through that.
Sure. The directorate's primary function is to receive the reports under Section 682, and like pretty much everyone here will be familiar with the reporting obligation on all liquidators of insolvent companies that they're required to report on directors' conduct, and then make an assessment as to whether or not the directors have acted honestly and responsibly, and then seek to be either relieved or not relieved of the statutory obligation to, at a minimum, take restriction proceedings against those directors. So our team take in those reports. Obviously, there is a compliance function there as well because there are statutory time limits to by when the liquidators have to submit. First report has to be within 6 months of the commencement of the winding up. That's statutory. We don't have any discretion about that. Then it's reports at such intervals as may be required by the CEA. Usually it's around 6 months. There may be, for other reasons, it may be longer than that, it may be shorter than that. So we kind of determine that once the first report is in, subsequent reports, then we will notify liquidators as to when their next report should be in.
I think we're going to talk a little bit later about the importance of that reporting and the supervision and the role. So sorry, I could have crossed you there.
Yeah.
And I suppose one of the key things is it's very, when the Irish economy here, 99% of people work in micro or SME companies, and we have a very heavily, I suppose, economy that's very heavily exposed to the SME. And we do hear about the CEA and previously the ODC involved in a lot of significantly large corporate prices, and we only have to look across Europe at the likes of the Wirecards and stuff like that. Like, do CEA differentiate? Can they or should they differentiate between large companies and say micro and SME companies?
I suppose the duties, the company directors, the same duties, regardless of whether it's a mom and pop operation or a massive multinational or a PLC. Like it's the same thing, if your members actually want to refer to the most recent information note about that was issued there about 2 months ago,
July, yeah.
to duties on directors and the things that a person should consider prior to accepting an appointment as a director of a company. That applies regardless. It's the same duties, it's the same functions that the director is expected to carry out. There's a certain standard expected of them as well. So obviously there's, like if you're a professional person, there's probably a higher duty on you, but there's still the basic standard of you need to keep advised of the company, keep advised of all the company activities, make sure that all the obligations have been complied with, make sure all the governance obligations are complied with. So there's all those sorts of things, and that doesn't really matter. And I think your experience, probably my experience certainly in revenue, would be smaller operators just seem to think that it's exactly the same as if they were running the business as a sole trader, and they're not really cognizant of the duties and responsibilities that come with the privilege of incorporation. And it is a significant privilege because, limited liability, the whole purpose of it, as we're all fully aware, is to kind of encourage entrepreneurship. There's nothing wrong with genuine business failure. And to be fair, the vast majority of the cases we come across are genuine business failures. But obviously, if you're not
that's an interesting point. And like, I suppose you mentioned my own experience. My own experience is like I would deal a lot with at the micro and the SME level is the spouse who, in the previous days, we used to have 2 directors like going on the board, and like it was nothing to me. I was just a non-executive director and trying to explain points that you're making. Well, actually, a director is a director is a director. Just out of curiosity, and I don't know whether you have the numbers off the top of your head or maybe you don't. The number of, you say that you talked about genuine corporate failure. Just curious, the number of actual directors who are actually restricted, in broad stroke percentage terms, is it less than 20%, 15%?
Like it's actually like in terms, I suppose the best way I can do it is like relief / no relief decisions. Yeah. And of all their decisions, about 68% are full relief.
Full relief.
That means that, like our assessment has been that the directors have acted honestly and responsibly.
So the vast majority.
Vast majority, yeah. But and I think that's something as well that would bear out with most other people's experience as well, out in practice,
I'm just curious, and obviously we're coming back and we're beginning to see, I suppose, in the marketplace, the numbers of insolvencies incrementally increasing year on year, particularly now as we come out of COVID. And I think it's interesting that one of the things is like COVID as an excuse, and I'm doing this long enough to remember when the crash was an excuse, and when you go back even further, every decade or so, there's something that's seen as not an excuse is the wrong word, but certainly is you hear it more often than not as a reason why a company failed. And I'm very curious, just the attitude, like when we look here and we focus on the fact, and ODCE as it was at the time, or CA at the time, released a statement that's very clearly as to what we're articulating now, the roles of the director and the duties of directors. But there tends to be, I think, amongst some, particularly at the micro and the SME level directors, the attitude that COVID is an excuse for not perhaps proper governance of their companies. And I see cited like not necessarily by directors but by other professions, safe harbour in Australia or in the UK, where reckless trading wasn't an issue. It was frozen as an action, for want of a way of putting it, by the UK government. Here, as we enter post-COVID and some companies are failing as a result of the action there, the simple fact is directors will be judged as they were pre-COVID, post-COVID, and how they monitored their business.
It's the same principles. Like and I think in terms of, I suppose if you look at the UK and like they've disqualified directors for fraudulently claiming bounce back loans, we didn't really have that process here, but there were subsidies like the e-ways and various business supports like that. And I'm sure I know Revenue kind of had a fairly robust compliance program to make sure that companies that weren't entitled to those supports have to pay them back. It's not something we'll ever look at in isolation. Like we always take a holistic approach to assessing reports. So one thing in and of itself will not necessarily be determinative of whether or not full relief will be granted or not.
You're bringing me back to my driving test. You're not going to fail it on one thing. Is what
no, exactly. As a general principle, like there may be evidence of conduct so egregious that it's very obvious that that this person deserves to be restricted. Actually, to be honest with you, if it is really egregious behaviour, chances are it'll actually go to disqualification rather than mere restriction anyway. So, but it's not that, like, we'll never just look at one thing. It's going to be the entire gamut of behaviour, and obviously we're depending on information from the liquidations reports, but also as well we have a very good relationship with revenue commissioners, and also there's a statutory gateway which allows us to share information with revenue, and revenue to share with us. So.
But now that you're an independent organisation, you're not you're not a member of the department on that. Is there an independence issue, or like CA is independent of revenue, of course?
Yeah. No, we're totally independent. There is a statutory provision in the Companies Act that allows us to share information. Like, obviously we're bound, like, well, as all civil servants are, we're all bound by the Official Secrets Act. But there's revenue employees, there's a statutory duty of confidentiality. CEA employees, there's a statutory duty of confidentiality, with that carve out that in certain circumstances we are allowed to share information with them. And we do that, and we make good use of that that gateway. And I suppose as well the fact that I'm formerly of the parish, and I have a very good working relationship with my former colleagues. Some of whom I understand actually might be watching this morning as well.
Good,
but there always would be that relationship there, and it's something that really put a lot of energy into fostering and developing and getting that information as well, particularly from caseworkers in the insolvency unit, because. And I'm sure, again, most of the people on this webinar will be well familiar with the various revenue caseworkers. So they'll have an awful lot of, I suppose, on-the-ground information about what happened at creditors' meetings that ought to have been reflected in the minutes, sometimes aren't, for whatever reason. But nevertheless, we'll have that information coming back to us as well. Yeah. And again, if there's any specific things that we would need clarified, or anything that we saw from the meeting, the minutes of the meeting, that's not quite sure about that, we have that facility to go back to revenue and say who was attending that meeting and could they actually provide a little bit of background information.
And it's important to say those minutes are a very important document and a legal document.
Absolutely,
and sometimes that enough importance isn't put onto them. And I suppose, like, moving on from the interaction with others, with say key stakeholders such as the revenue commissioners, how are you finding, say, interaction with individual insolvency practitioners on an individual basis, and insolvency practitioners as a whole, or other representative bodies such as CCABI, for example, or indeed RII? How are you finding the profession reacting to CA and interacting with CA?
It's very positive, and it's very heartening for me to see actually the reaction. And I was actually quite pleased as well when I joined first that a lot of practitioners, and I suppose I would have known quite a few of them fairly well. I've been dealing with quite a few of them for like a long number of years now. So like, it was actually very nice that people made it their business to get in touch with me, and I have been in touch with obviously yourselves, certain members of the committees, also RII as well got in touch with me. So like, I'm building those relationships with various stakeholders as well, because ultimately, we're dependent on the input from all of your members to ensure that they were getting the results. Your like liquidators, in my view, are key. They're key figures in ensuring effective corporate governance, ensuring effective orderly winding up the companies, and ensuring creditors are adequately looked after and protected as well. So all of those relationships are very important to build on and nurture.
The current communication channels are effective through the various bodies, or is there anything you'd like to see improved? Or
so far so good. Like, again, it's all very early stages, and as I said, I am kind of engaging with various practitioners on an individual basis, but also on a collective basis. So we're trying to just develop something with the various stakeholders, and obviously opportunities like this as well are really excellent. We welcome anything like that. It is kind of a key part as well of the CEA's function about advocacy and outreach, because it's very important to educate people on what the expectations are of them, and what the expectations would be in terms of like ensuring the company law is complied with on directors levels and so forth.
So moving on from that education piece and moving on to, I suppose, insolvency numbers and appointments are on the rise. Like, it's certainly, we're seeing it in the various, some of the firms published figures. You can see it going up in the quarter. I can personally speak from personal experience and say that this summer, for example, I saw more companies looking at CVLs than for many years over the summer period. Summer period tends to be quite a quiet period. Didn't see that this year. So, seeing that the numbers are rising, I suppose, from your point of view on that education piece, what are the key issues that perhaps IPs as a whole broadly need to address in terms of reporting, perhaps to yourself, or in terms of, some of the issues that are coming across, you're seeing coming across that IPs are facing in the companies that they're liquidating, and perhaps may need a little bit more attention directed to them or not?
Well, I suppose there's always a 6-month lag.
Yeah.
We're not going to be getting the reports for any of the companies that went into liquidation, say it's the 1st of June until like the end of the year, or 1st of January. So we always have that bit of a lag. Like certainly in terms of the appointments, we're not quite back at 2019 levels yet. We're about 8% under based on August figures now. I fully anticipate that we will be up at and surpass. I'll be getting the September figures now this week. So we're very much getting there in terms of back to normal service activity levels. It'll be interesting to see now with the further unwinding of the various COVID supports, what sort of impact that's going to have now from within next May on. Like there has been a tapering off, and I think that's obviously had to be the case. But it'll be very intriguing to me anyway to see what sort of impact that has now for next year in terms of the overall trends.
Are you seeing in terms of trends any particular sectors?
Again, like we expect the NACE codes to be furnished for all the companies as well. Like hospitality has always been one that's up there, and I think that's certainly in terms of the last month's figures anyway. We did see a bit of a spike in hospitality liquidations and insolvencies. I suppose getting back actually to the question you did ask me, in terms of like what we want to see from liquidators, the first report, well, we want them in on time, and for the most part, most practitioners do have them in on time. It isn't for the want of being reminded. The first letter goes out when we receive notification of the appointment, and that notifies the practitioners, who all should be fully aware of the fact that they've took their first report in 6 months. Then they get a reminder at the 5-month period, and then a further reminder at the 6-month period. Now, as I said, the compliance levels are pretty decent. There was a bit of a drop over COVID. You can probably understand that to a certain extent with remote working and all that, but nevertheless, with the first report, we don't have any discretion on it. Second report, we do to an extent, but it's 6 months, and everybody should be aware of that. We started a review, and this is kind of kicking off, because I was talking earlier about the compliance program that we're beginning to start now, because we actually have the additional legal resources to run these things. So we are now issuing 797 letters, and hopefully few if no people who were attending this morning should have actually got a 797 letter from us to say that they are in default because the report has been submitted late, and if that isn't rectified, then obviously further action will be taken. We're now down to a small enough cohort of liquidators who still haven't filed a report despite repeated reminders and engagement. So we will be issuing proceedings against them to compel their compliance with the Acts. The 797 process is a general process which allows the authority to apply to the High Court to compel a person to comply with the provision of the Acts. So we're utilising that on the basis of, I suppose, a graduated enforcement programme. We're going down the civil route first. We try to secure voluntary compliance. I think that's kind of that's a philosophy that applies across all the directorates in the organisation.
I think it's fair to say in relation to that, like the first, the mandatory, the 6 months that you have to have in, it can be a holding report. It's possible to send in a report.
This is it. I don't think there's no real expectation that there's going to be a major progress done in the first 6 months. I think it would be unreasonable to expect that you're going to have a huge amount of work. But that being said, we want to see some bit of evidence that some bit of work has been done. Subsequent reports then, like certainly, I suppose my experience would be it takes about like 18 months to 2 years on average for a fairly uncontroversial winding up to be completed. So we really need to see some evidence of significant progress by the time at the third report is in. And again, because we have more resources, we can begin a more robust follow-up on that. We have the liquidators are obliged to give reasonable compliance and answer any questions as are put to them as may be reasonably necessary to for us to discharge our own functions. So we will be doing that on a more, we have done it already, but we'll just be doing it in a way more robust basis going on into the future. And we do expect to see kind of significant progress and significant developments as the liquidation goes on, rather than investigations are ongoing. To be fair now, and there's, most liquidators are good at this, but there are a few people it's minimal enough detail. Investigations are ongoing. That's not enough. That's not sufficient.
And is it fair to say, and we've had this conversation, Emilia, it's not just, there might be an attitude, well, that's probably guys or girls who are doing the odd liquidation who are not. But actually, I think your experience is it's actually people who do a volume of liquidations are included in the numbers who perhaps maybe you would have thought.
As I said, the vast majority of liquidators do a very good job. But I suppose there is an element of people who mightn't have quite as much insolvency experience, but also there's people who take a fair few appointments. I'm not saying a massive volume of appointments. People who take a fair few appointments who really the standard of the reporting is not quite what we would expect. There's a trend as well that some of my caseworkers alerted me to, of just a basic copy and paste of the director's statement as an outline of the reasons for the insolvency. That does not speak to me of a practitioner who's actually kind of done any sort of interrogation of the reasons for insolvency. None of us really care what the director's reasons are. That's important, it's a factor, but there has to be a verification of those reasons, and that's the liquidator's function. So it's not good enough to just take the director's statement for the reasons of insolvency that they read out at the registrar's meeting and just copy and paste that into a report. So we will be actually following up on that, and again, I suppose, added into any information that we'd have from our colleagues in revenue as well, and putting those type of things to the liquidators.
We have a number of questions coming through, but I'm going to leave them for a few more minutes till the end, okay? So if we were to summarize what practitioners are doing wrong, it's mostly on the timeliness of the reporting and on the cutting of the pace. Is there, as opposed to conducting, an independent, if you like, a truly independent third-party review of the company? Do you think is there a danger out there that some of the companies, the size and the nature and the assets, the realization that they get the investigation, their size maybe can afford, as opposed to warrant, if you know what I mean, that sometimes that these liquidations are small and that there's a view taken as opposed to a proper investigation coming? Does that come through in reports, or is it simply a situation that perhaps
it's it's not something, I suppose, that will be glaringly obvious to us. It's obviously, I think it would be naive to think that it wouldn't be a consideration for certain people. But again, because we have a lot of information from revenue, we're able to interrogate that. And, obviously revenue have a huge amount of information about companies' insolvency and their engagement with the tax authorities prior to the liquidation. So we will take all of that into account. But I don't think there's any kind of real apprehension out there that a blind eye has been turned to it. There was actually a case where a liquidator saw full relief, and based on our own investigations and information, plus information we got from other sources, and it's quite obvious to us that further interrogation was needed of it. So there was pushback from this is an ODCE case, in fairness now, it's quite a couple of years ago. But we do push back if we think that there's a reason to push back. And I suppose mercifully there doesn't seem to be a reason to push back in the vast majority of cases. But again, we are kind of led by the quality of reporting, but also I suppose it's very important for people to know that we actually have access to quite a lot of information from other sources as well. So if it's a thing that there's issues of concern, we could have it in the form of complaints from the general public as well, and that's, I think, important to bear in mind. We have the complaints function. We often get complaints from creditors or former employees, and it can be quite surprising the amount of information we would glean from those sources as well. We'll actually feed into our decisions.
And do you get much in terms of filtering whistleblowing? Because we all know when we deal with the public that there's a lot of very good stuff comes through, but sometimes there's a lot of spurious stuff that comes through.
Well, I think I suppose they're two different. The whistleblowing and the protective disclosure process is entirely separate to the complaints process. So from the point of view, and there's various, and I'm not going to, because it's not really, I suppose, something that's the core topic this morning, but I'm not really going to go into too much about the criteria for a disclosure qualifying as a protected disclosure.
Oh, yeah.
Like the numbers of that are pretty small. I think it's
No,
only about
I meant in the terms of, say, a creditor and
Oh,
an
in terms of actual
creditors,
complaints,
yeah.
Again, we get a good view, but like again, I suppose you kind of feed that into like it's those complaints are fed into our own internal processes as well. So you get a fair sense as well whether or not there's something legitimate. Yeah, all my caseworkers are very, very experienced in my team, so they have a good old horse sense of whether or not something is just kind of airing of grievances or whether there's some legitimacy to it.
So a key part of your role as well is liaising, with your fellow practitioners at the same level in other jurisdictions, both in Europe and internationally, and particularly as part of Europe. Do you see, what are you seeing in terms of the development and promotion of best practice within, I suppose, future legislation and conversations coming down the track? What are the trends that you see that's out there, I suppose, amongst other jurisdictions in the EU that may impact us here going forward?
Sure. I'm only just back now from the International Association of Insolvency Regulators conference there, just held in Belgrade there 2 weeks ago. So that is a properly multinational organization. Like there's representatives from all over the world. It's not just like actually the EU is quite a small part of it. Like this UK, Scotland, the States, Chile, Peru. Singapore, Hong Kong. It is properly multinational. There's Australians, New Zealand as well. So, from the theme of the conference this year was about data and digitalization. So I think that's kind of a big hot topic now in terms of like the systems that can be developed to, I suppose, get better results in terms of insolvency as well. Like the difference as well, because a lot of the very developed systems in Europe tend to be civil law systems, which is radically different, obviously, to our own system as well. But I think one thing as well that came through is crypto, and two very, very interesting presentations about how to handle crypto in insolvencies and restructurings, and that seems to be a particular issue in the US and in Singapore. So my colleagues from those jurisdictions give two very interesting presentations. I don't think it's something we haven't really seen it here too much yet.
Yeah,
I think it's probably the size and also I suppose the geographic positioning of those particular jurisdictions will probably lend themselves to kind of encountering those issues a bit more. But that seems to be kind of one of the hot topics at the moment internationally from my fellow regulators and enforcers.
Because and we've had a thing over the last couple of years about the whole earning warning system, and CA published a guide in that earlier on this year. The reality is, it comes back again. I think it's fair to say directors doing what they should have been doing all along, in effect, monitoring their business. Is that fair?
Yeah, I think so. And again, there was my colleagues David Hegarty and Michael Dimmy hosted a workshop with one of our Finnish colleagues in relation to the early warning tools that can be utilised. And I suppose again, like the approaches are from kind of having nothing at all to having a kind of an algorithmic tool that you put in all the information into, and it tells you whether or not this kind of a traffic light system as to whether or not you're okay, you need to maybe take steps, or you're in dire trouble. There's also certainly in Finland, there's like a counselling session type of thing. I suppose to bear in mind as well with the insolvency regulators, it is a mix of personal and corporate insolvency. A lot of jurisdictions actually manage all of their insolvency, regardless of whether corporate or personal, in the one body. We have a separate function. Australia have a separate function, but as far as I know, we're the only two jurisdictions that actually have that separation.
Okay.
But the early warning is as relevant, and I'm not going to talk about personal insolvency too much anyway. But the same principles apply anyway. Really.
Yeah.
I suppose from our point of view, we have guidance rather than counselling or kind of an algorithmic tool or something like that. But again, I do think it's useful information. Obviously, bigger companies will have more professionalised directors as a rule. They're going to have a better knowledge of what needs to be done. But again, part of the CEA's function is to get that information out there and to educate potential and current company directors as to what their responsibilities are. So that was the purpose of the early warning tools information.
Okay, I'm going to move on to some of the questions that have come through the open chat box, and I'd encourage anybody now who have any questions just to now is their chance to put them in, and we go through them over the next 15 or 20 minutes. An interesting question. Has the CEA petitioned or used their power to appoint a liquidator? If yes, can you outline the circumstances?
Not yet.
Not yet.
Not yet. We haven't actually come across a case that we believe yet would actually merit a public interest winding up. That we will definitely be using that power as soon as a suitable case comes up. There's procurement issue as well in terms of the getting a liquidator, but that's something that we'll be able to address now as well. We are in the process of addressing that too. So it will, like, we're not like the UK where they have the official receiver. So it is a different system. So that is a function that will need to be outsourced. But again, once a suitable case comes along, we will be looking at it again. We're liaising with our colleagues in the UK in terms of like the types of cases that they look at and the types of cases that we should be looking at. But I suppose we haven't got it yet, but we will do.
And that leaves the question: is it a panel system that you'll have?
I don't know. It's all been kind of teased out as to what sort of procurement we would need. But again, because our system is different to the likes of the UK, we more than likely will have to do that.
It's evolving as we speak.
It's all will be revealed in due course.
All be revealed. Okay. Has the CA, second question, has the CA powers to take control of a corporate structure that are in the public interest? And it's a similar version, and I think the answer is you have. Is that fair to say?
Yeah, I suppose there's also the facility to appoint an inspector as well, and that's been utilised sometimes too. So it's not quite the same thing, but again, like there's the power to order an inquiry into the affairs of the company.
And would that be led by? I presume that's led by matters that are brought to your attention, or like do you proactively go out and look for issues, or is it a matter? Do you react, or are you proactive?
I think enforcement, because we are the corporate, like as the name suggests, we do have what it says in the tin. We're enforcers, and enforcement is by its nature reactive. Like I think there might be kind of a perception out there that we're a regulator. We're not. We're not like the central bank who regulate. They don't conduct inspections. So I suppose our function is more analogous to maybe revenue or the guard. Well, revenue maybe not so much as well. Like I suppose they do inspections and audits, but certainly like the guards would be reactive as well. So we too would kind of act on information that comes to our attention or complaint or protected disclosures.
Next question. What is the CA's experience of apartment owners, management companies where residents and property owners act as directors? The companies are CLGs, but have very significant financial obligations. What's your view there?
I'm not going to comment on my view of it, but suffice to say that the civil enforcement assessment section, like quite a few of the complaints would be about management companies. All right. So
the director is a director is a director.
The only message I have is a director is a director is a director. It doesn't matter. That's there's still the same duties and responsibilities.
Okay. So next one, do you think we will move to a requirement for annual/biannual certification for at least one of the company's directors to undergo training or certification? So more than a tick box exercise for the board of smaller enterprises, or is that too much admin for boards, companies? Membership of the Institute of Directors can be very expensive.
Again, that's a matter of government and enterprise policy, which I won't be commenting on.
Yeah. So I suppose my own view, like, and I know you can't view, my own view on it is that when you have a micro and an SME, the reality is the education is out there, and the likes of the early warning. Again, I've spoken on it for a couple of the county bodies in Denmark and a couple of places on it. Sometimes can you lead a duck to water, or a horse to water, that kind of way. And the reality is, as you said earlier on, this is my view, not yours, is that being a company director, there are many, many advantages, and with that, those advantages come responsibilities, and ultimately, people have to inform themselves. It's as simple as that. Well, that's my view.
That is the message I would like to get out there. Limited liability is a very significant privilege, and with that comes very significant responsibilities, and it is incumbent upon people, if they don't want to meet the business end of a restriction or disqualification application, then it's incumbent upon them to make sure that they are aware of those duties and responsibilities and take steps to fulfill them.
So good morning, Cathy. Tom, seeing this in CVL cases where revenue may request restriction re possible abuse of COVID waste subsidiary supports, but the CA appeared to take a wider approach of company over its tenure and compliance and not necessarily look to restriction. So I suppose the question there is revenue would perhaps, in this question is suggesting that revenue would perhaps take a narrow focus on the actual, abuse of COVID waste subsidy, but CA seem to be a little bit more take a longer or an all-encompassing view of the tenure of the directors.
Well, I'm not going to comment on revenues function. Yeah. Suffice to say, I find it frankly very surprising that, and I've heard this is not the first time I've heard this about revenue requesting restriction. It's not up to revenue to request restriction. And certainly my experience would be we don't request restriction. And I'm talking with my formerly of the revenue power chat. Certainly we would ask the liquidator to look at certain things or ensure that certain matters were noted all right, which isn't quite the same thing as requesting restriction, and actually isn't the same thing at all as requesting restriction. And furthermore, revenue are not, because the CEA is an independent body, we will absolutely take any information we get from them and take it very seriously. But ultimately the decision as to whether or not a director is to be relieved or not relieved rests with themselves.
But I think it's also important to say that, obviously in the period leading up,
independent too. So.
Well, the liquidators are independent, yeah. But I suppose the point is that the last 12 months leading up to a liquidation are particularly important, like the actions that a director take at that particular time. But ultimately, it's your tenure as a director. The squash case, if you want to go back 30 years ago, looks at the tenure of directors, and ultimately, COVID is an important part of the role, but it's not the only part. I think that would be my
no, it's not. I suppose again, the takeaway is it's not a get out of jail free card. There's plenty of businesses. So every single business to some degree was affected by COVID. And, just because a business failed doesn't necessarily mean it was because of COVID. It might have had an impact on it, and more disproportionate impact than another business. But nevertheless, there's still businesses going strong and coming back and have done quite well post-COVID. That is not, it's not the one size fits all excuse anyway. And certainly that will be the view we take of it, albeit that we will never look at anything kind of in isolation. As I said, everything will be looked at in the round. But you can't just say, oh, COVID, and somehow expect that to absolve you of all your sins.
The complete tenure, the overall tenure of a director. This question, I think we've kind of addressed, but we'll ask it anyway. But I think we're going to have a similar answer. Also, non-executive directors, CA appear to take a more relaxed view re-spouse directors of SME micro companies and are more so nominee directors for pre-2014 Act companies. Do you have a general view on this? I think we've kind of addressed that in the reality as a director, and the companies.
As a director, Judge Faherty's decision back last July in terms of the Appleby decision, which I think was very well publicised. Court of Appeal have said it doesn't really matter if you're non-exec or not. You still have the same level of responsibilities, and you still have to. And again, I suppose it's important to emphasise the duty is on the director to show that he acted honestly and responsibly. So that's where the burden of proof lies. It's not actually hard to show that you've acted honestly and responsibly, in my view. So it's you actually just have to take a genuine interest in the company's affairs and make sure that you're doing make sure that you yourself are advised of what's going on in the company. And that's incumbent upon you, regardless of whether you actually take a day-to-day role in the running of the business or not.
And I think it's actually in the notice that you released in July, or CA released in July, that if you're asked to be a director of the company and told you just have to turn up the odd time and sign the odd document, the senses should be heightened. And I'm paraphrasing the document,
if something, as a general rule, if something seems too good to be true, it generally is. There's not many things that you'll get money for old rope. It's certainly if it's been presented in that way, that should set somebody's alarm bells ringing. There's no such thing as easy money.
Okay. So another question, just to because I'm very conscious of time. Would you know, and we've kind of addressed this, and I think you said earlier on that around 70% of, just slightly shy of 70% of all Section 682 reports result in full relief. But the question here is, would you know the percentage of released decisions excluding revenue petition liquidations? That obviously, well, I think what the question is saying that is that obviously that when revenue have to go to the considerable time, effort, and cost of going to appoint a liquidator, that there are serious issues there, right? But as opposed for the non-revenue petitions, is there any
We don't
clarity in
actually.
the numbers?
No, unfortunately, we don't keep figures like that. As well as that with CVLs, I suppose, which would be the bulk of the appointments anyway. In the last couple of years, the 570 process has effectively been suspended, I suppose, more or less.
Yeah.
So that I suppose you could almost take it for granted that the overwhelming majority of official liquidations would have been revenue petitions. But for CVLs, it isn't quite so clear. Certainly our system hasn't the capability to distinguish between revenue and non-revenue, and frankly it shouldn't anyway. So my view would be, I don't think that we will ever keep those statistics because I don't think it's relevant. Like we'll always go on, like we'll get the information from revenue, but like certainly our view is not going to be coloured regardless of who appointed the liquidator or not. Because the liquidator still has the same, regardless of who appoints the liquidator, who nominates the liquidator, it's going to be the same functions that the liquidator has to discharge one way or another. So I can see where people are coming from with this, but like I would just want to make it very, very clear that the information we get is very valuable, and I'll continue to say this, but it's not going to ever be determinative of whether or not we give a relief or no relief decision. It's going to be based on the director's conduct and based on the reports of the liquidator that the liquidator gives into us.
Super. Okay, here's an interesting one. Will the CA provide funding in a case where a liquidator is directed to take action against a director, but there are no funds available in the liquidator to take the action to the High Court?
Not in our mandate to do it.
No.
And like I think this is an issue actually. Like in terms of like funding, is this like an issue that has been identified and by the liquidator, but they don't have funds in the liquidation to?
I think we can take it from the purpose that that's the case, that there is issues in the liquidation, but ultimately that there's not enough assets to cover the liquidator's costs in pursuing the director.
Yeah, no, unfortunately not in our mandate to do that.
Okay.
And also, actually, it's part of the liquidator's responsibilities to, ensure the orderly winding up of the company, ensure the full investigation. By all means, if they have evidence of criminality or anything like that, well, there is the obligation to report it to the CEA and the DPP. So I suppose that is one avenue. But in terms of like funding civil proceedings, that's not within our remit.
In your remit. Okay, the last question, just like to say to anybody, if they have any further questions, just to pop them in now, because we're coming towards the end of the question and answer session. I'm expecting trading, there's one question, I'm expecting trading with unrealistic expectations of recovering and paying off warehouse revenue debt be a substantial issue in upcoming cases. A lot of directors have bought the line that they were right to continue trading based on reports in the media, etc. Have you seen or heard of any court decisions on this area as of yet, or have any judges given a view?
No, and I think again that's a function of the fact that COVID supports probably still haven't fully tapered off. But again, I just find it absolutely extraordinary that people would think that that everybody in the country knows that the supports are not going to continue on indefinitely. Every company director should be fully aware of the fact that if they continue to trade, they could find themselves at the business end of a reckless trading application at a minimum, or and restriction at a minimum, or even disqualification. So it is fairly extraordinary that people will kind of continue on in the expectation that things are going to get better. Like if you have a mind to look at your management accounts or look at the general, like again, going back, look at the early warning tools that we published on our website. If you're looking at that and you're assessing your business and you're saying that, well, maybe just maybe that we'll turn a corner soon. If you haven't turned a corner and things are only going in the one trajectory, and that's a downward trajectory, I think you really need to kind of take very serious look at the business and take serious professional advice and decide on the course of action from there on in.
Now, there is, and I think it's important to say that obviously under the 2014 Act, it's actually now codified that directors have a duty once they think the company is insolvent or there's potential
exactly.
that the company becomes insolvent.
You have to, like that's a new provision as well. You have to consider the interests of creditors. That's going to be something, and you have to consider the interests of your employees. And actually, that leads me on to this is something that I want to get out there. Really want to get out there is the new form that's been prescribed for Section 682 reports. and Mr. Darragh O'Leary signed the statutory instrument there late last week. It is effective from the 1st of October. So every report submitted to the CEA under Section 682 that's dated on or after the 1st of October should be on the new form. I think that's actually up on the Chartered Accountants Ireland website. I think I saw that yesterday evening. It's on the CEA's LinkedIn page as well, a link to the regulations and the prescribed form. So it would be very useful if everybody could note that from the 1st of October, all 682 reports have to be submitted on the new form. It's more or less the same as the old form. There's just two differences. Number one is an inclusion of question about whether or not the liquidators have to confirm whether or not the directors have had regard to the interests of employees. And the second question is actually a subheading of the question in relation to whether the directors have acted honestly and responsibly. If a liquidator is seeking not to be relieved of the obligation to restrict, then they have to indicate, and it's a tick box, yes or no, whether or not they've actually advised the directors of the grounds in which a restriction application will be brought. And that's really just, that's kind of to facilitate us when we're offering undertakings. Like that's actually part of the process, and one of the very important functions of the Insolvency Supervision Directorate to offer restriction or disqualification undertakings to directors. So the directors sometimes will say, I knew nothing about this. The liquidator never told me anything about this. More than likely is not true, but because I think any liquidator worth their salt will have engaged with directors insofar as is possible, and they should be fully aware of exactly what has gone on and what the liquidator has found. But nevertheless, just to, I suppose, to short circuit that process, there's been an inclusion on that, and it's a simple tick box yes or no. And if there's a reason for no, like directors have left the jurisdiction or directors have decided to make themselves uncontactable, then just we just need to know that, because it informs us when we're actually going through the process of offering an undertaking.
But in fairness to that particular point, I think it's certainly 15 or 16 years ago, there was a case where the judge actually said, and certainly in the early days of the old Section 56 reports, that actually best practice was that you should give a copy of your draft report to the directors. But ultimately what you're saying is there's a checkbox to make sure that the liquidator actually did, if in effect did that.
Well, we can always go back. If the director says, I knew nothing about this, then we can say, well, actually, we have confirmation. So it's another little bit of information that's useful to us in terms of streamlining our own work. Okay,
so actually a couple of other questions have just come in. Should we include these restriction notification letters with the Section 682 reports going forward? Or is a simple tick enough, or should we give you a copy of it for your files as well?
Hang on now. Can that be clarified, actually, because I'm not quite sure what that means.
So for example, if for example I'm appointed liquidator company and I'm restricting the director, and I give them advance notice that I believe you should be restricted on the grounds of X, Y, and Z, and my report is going to be submitted to ODCE on that basis, and I give them a copy, and what our practice is a draft copy.
There's no requirement, and the prescribed form, it's just, please just say you've advised them yes or no, and if it's no, then just please tell us why you didn't advise them. It doesn't need to be a massive narrative. Obviously, if anybody wants to include that correspondence, the more information we have, the better. But there's no requirement to do that.
And the last is a question is more common, that in relation, I think, to the earlier question about will the CA provide funding in a case where liquidators direct to take action, but there are no funds available. It just effectively a comment that the creditors continue to pay, and now a liquidator could have to pay. Well, I suppose ultimately that comes down to the liquidator making a commercial case. They are commercial business people at the outset of the case in that regard. We're coming up to 5 to. That's all the questions in the question box. I'm going to just change tack just because the point of today was to get to know you and to get to know the work that you do. So I'm going to ask you if we can just finish with 4 things. If you can recommend favorite movie, favorite song or an album, favorite book, and where your favorite holiday destination is. Just to close off.
Favorite movie would be I keep going back to The Snapper.
Snapper. Okay, very good. Yeah, uncontroversial, I have to say. Very good. Yeah.
I know I think it hasn't aged very well, but it brings back memories. I think it was the summer of 1993, which was very, very wet. and myself and my cousins, because we really hadn't an awful lot to do, pretty much watched that on video every single day for a whole summer. And we still, like, we quote it anytime we meet up, we quote it extensively, and it still brings back good happy memories of being a kind of under-occupied teenager across Scotland.
So the movies of our youth, are you infected? What about is it the music of your youth as well?
The music, yes, and this, as I think I said to you yesterday, this is a very difficult question. It might be easier to ask me to pick a favorite child than out of my three. What I will do, and this is kind of cheating a bit, I will actually recommend a playlist on Spotify, because I think that's probably fairer, and it's Electric Lady Studios in New York, which is pretty much it's an absolute who's who of recorded music. Studio was founded by Jimi Hendrix. That playlist is 10.5 hours long. There's something for everyone in it. There's like Patti Smith, Taylor Swift, Kanye, The Weeknd, Beastie Boys, you name it. There's something for everyone in that playlist. It's absolutely.
I think anybody with kids is a Swiftie these days, or they have no choice to be.
Well, true. I mean, anybody who went through the trauma getting tickets for the gig.
Or what's worse, the trauma not getting tickets. That'd be even worse of a trauma. So finally, listen, we find us a favorite book and a favorite holiday destination.
Favorite book, pretty much anything by John McGahern. He's actually, I am from very near to. I'm originally from very near to where John McGahern grew up. So I suppose a lot of his writing would resonate a lot with me in terms of, I suppose, the characters that he describes, and the type of scenarios that he deals with in the book, in his many books, and they're amazing. Holiday destination, New York, always New York, forever.
It's not shopping now, Cathy, is it?
It's not. No. Well, like, we've our family over there, but like, it's I have been there more than I have been anywhere else, and I never get tired of it, and I go back again next month. So
super. Well, listen, Cathy, all I can say is thank you very much for taking the time, not only today, but also you've obviously liaised with the committee, like leading up to this, and being open and frank with a lot of the questions, and it's much appreciated. And ultimately, if I'm summarising the do's and don'ts from the CA experiences, really for us liquidators is. Timely reporting is so important, and using the right forms is also going to be very important going forward. And obviously, open interaction with the CA is welcome and encouraged. So, listen, thank you very much. It's very much appreciated by us.
And thanks as well to Laura Michelle for facilitating this as well. It's been a great opportunity to have a chat with yourselves and just get the messages out there. And I suppose we're always interested to hear from the representative bodies if there's anything as well that they think that we could be doing to assist them too.
So listen, thank you very much, Cathy. Talk to you soon.
Thanks very much now.
Bye-bye.